We're good? Good morning, everyone. Thank you for being here for this work session around Senate Bill 11. We obviously, there's a tremendous amount of interest in this bill. And so our plan is to go through the amended version, and then we have folks who have signed up, and we'll bring folks up, give folks an opportunity to speak on the bill in groups. And so we will get started with John. Is John going to start it out?
I'll start us off.
Okay, Patrick is going to start us out with the bill. Thank you.
So you all had a chance to pick up a reprint that we had out in the hall, and generally this, for those of you who were on the distribution list, except for one small change, is the same as what was sent out electronically a couple days ago. But just generally, these amendments have been drafted to align with the Virginia Consumer Data Protection Act. So just kind of going through the reprint, we'll start with some of the definitions. You'll see that child is defined as an individual under the age of 13. Moving ahead, the definition of consumer. This does not include an individual acting in a commercial or employment context. The Virginia Act uses the term controller and processor, and here controller, generally speaking, equates to a business, as that's used in Senate Bill 11. So this is defined as the individual or entity that alone or jointly with others determines the purpose and means of processing personal data. Just a couple other things I'd highlight. The one change is that there was an omission. The definition for a nonprofit organization has been brought into this set of amendments to align with the Virginia Act. That's on top of page 4 of the reprint. That a nonprofit organization means an organization that's tax exempt under 501c3, 6, or 12. A little bit further on, the term process or processing when used in the bill means an operation or a set of operations performed, whether by manual or automated means on personal data or on sets of personal data, such as the collection, use, storage, disclosure, analysis, deletion, or modification of personal data. And then right below that, here's the term processor. That term is generally the substantive equivalent to a service provider as used in Senate Bill 11. I'm just proceeding to page 5 of the reprint. We have a definition of sale of personal data, and here it means the exchange of personal data for monetary consideration by the controller to a third party, which I believe is a narrower term than what's used in the California Act that uses valuable consideration. A little bit further below, there's a definition of sensitive data. And later on in the bill, and John will touch on this in a minute, but it's for sensitive data where consent is required for the processing of this kind of information. And so that sensitive data includes personal data revealing racial or ethnic origin, religious beliefs, mental or physical health diagnosis, sexual orientation or citizenship or immigration status, the processing of genetic or biometric data for the purpose of uniquely identifying an individual, the personal data collected from a known child, or precise geolocation data. So I think that is it. I'll hand it over to John Travers, my colleague with the Department of Legislative Services, and he'll walk through some of these additional sections in the bill.
Good morning. So I'm going to start with 14-4402, the applicability section. This subtitle applies only to a person that, this is A, only to a person that conducts business in the state or produces products or services that are targeted to residents of the state, and during a calendar year controls or processes personal data of at least 100,000 consumers, or controls or processes personal data of at least 25,000 consumers, and derives over 50% of gross revenues from the sale of personal data. I also want to call your attention to B. So this subtitle does not apply to and we have in 1, governmental entities, 2, financial institution or data covered by the GLBA, the federal GLBA. 3, we have a covered entity or business associate governed by, and as you can see, these entities here. 4, we have a nonprofit, which, as we said earlier, there was, we've defined elsewhere in the latest copy. So if you don't have, if you printed out an earlier copy, it might be elsewhere. And 5, higher education institution. Continuing on a few pages, we're going to go to page 12 of 34. This subtitle does not apply with respect to, and we're going to 13, data processed or maintained in the course of an individual applying to, employed by, or acting as an agent or independent contractor of a controller, processor, or third party, to the extent that the data is collected and used within the context of that role. Next, we're going to move on to 14-4403, and I want to call your attention to A2, a known child's parent or legal.
Slow down 1 minute, please. You said we're on 14403 we just bounced to?
Yes, sir.
14403, thank you.
Yes, sir. And A2, a known child's parent or legal guardian may invoke on behalf of the known child the consumer rights regarding processing personal data belonging to the known child. Next, we're going to move to the next page, V, to opt out of the processing of the personal data for purposes of 1, targeted advertising, 2, the sale of personal data, or 3, profiling and furtherance of decisions that produce legal or similarly significant effects concerning the consumer. And we wanted to call your attention to this portion of the bill right here because it's a little bit more limited than what was in the original Maryland bill. We also want to highlight your attention to B, which is just below that. This is where the timeline and response mechanisms are drafted out, and so we also want to call your attention to, on the next page, to Roman numeral 1, and this is what is required in the response. And on the next page, we're going to, in C1, this is the establishing an appeals process, which was not in the original Maryland bill as well. We're going to move on to 14-4404, and we're going to start with B1. This subsection may not be construed to, and then moving to 2, prohibit a controller from offering a different price, rate, level, quality, or selection of goods or services to a consumer, including offering goods or services for no fee if, and I'd like to call your attention to the the offer is related to a consumer's voluntary participation in a bona fide loyalty, rewards, premium features, discounts, or club card program. Just below that, I'd also like to read, a controller may not, except as otherwise provided in the subtitle, process personal data for purposes that are not reasonably necessary to or compatible with the disclosed purposes for which the personal data is processed as disclosed to the consumer, unless the controller obtains the consumer's consent, which is something that that Patrick had highlighted before. Moving on to F1, which I have on my next page. It might be different in your copy, but F1, starting each controller shall, and the Roman numeral 1, establish a privacy notice that includes a description of one or more secure and reliable means for consumers to submit a request to exercise their consumer rights under this subtitle. I just wanted to highlight here that it is the case with this amendment that the notice requirements are more limited and that at or before the point of collection does not appear in this provision. And then we are at 14-4405. In the interest of time, we're not going to go through this one and read off any of the provisions, but obviously that does not prevent you from addressing them later.
Yeah. So yeah, just for the sake of completion, for this section of the bill lays out the respective responsibilities of controllers and processors. If we go to page 12 of the reprint, there are provisions here that establish a requirement that controllers conduct a data protection assessment of specified processing activities of personal data. On page 13, there's a provision that authorizes the Consumer Protection Division to request that a controller disclose this assessment and evaluate it for compliance purposes. A little bit further below, there's a section that deals with the processing of de-identified data. I won't go into detail on these. On page 14 of the reprint, we have a section that lays out some of the limitations of the Act. For example, on page 15, it can't be construed to restrict the ability of a processor or controller to protect life or safety or prevent, detect, or protect against or respond to security incidents, theft and fraud and what have you. There are some additional provisions below that authorize certain data collection and use on the bottom of page 15 of the reprint. I think I'll jump to page 17 of the reprint. Here's the section that deals with enforcement. And like Senate Bill 11, a violation of the Act is an unfair, abusive, or deceptive trade. Senate Bill 11 is introduced. A violation of the Act under these amendments would be an unfair, abusive, or deceptive trade practice under our state's Consumer Protection Act. But one important difference here is that there's an exception where it would not, that the enforcement and penalty provisions of that act and this specific section that would authorize a person to bring an action for damages would not be applicable to a violation here. And then there's some additional language here that I'll flag for you, that the Consumer Protection Division would have to provide an opportunity to cure a violation before initiating an enforcement action. And then maybe the last thing to note here is there just is some language here that makes clear that there is no right of action authorized for a violation of the Act under this set of amendments. So I think maybe that's a good point to stop. And
That's good.
okay.
All right, fantastic. All right, so as we said, first of all, members, do you have any questions for, yes, Senator Bidle?
That's my name. You did good.
I'm not used to being over here and looking at you, Pam.
Thank you, Chair. So basically what we've done is we struck all the language of Bill 11 and replaced it with new language. I love when that happens. But I had a question this morning about the definition of financial institutions. And I know that you say financial institution that is ruled by the Gramm-Leach-Bliley Act. I had it circled and it was a couple, yeah, it's, I had it circled and I've lost it. Okay, it's on page 6. This subtitle does not apply to a financial institution or data subject to Title V of the Federal Gramm-Leach-Bliley. Are there subsidiaries of financial institutions that might not be subject to that the Gramm-Leach-Bliley Act?
So first of all, I don't think that the term financial institution is defined in this set of amendments.
That's a problem.
In terms of whether there I know there are other places in the bill where there's reference to affiliates or subsidiaries. I think we have some folks who are more expert on what may or may not be included under the language that we have in the bill who can speak to this, but I will flag that term is not defined and it doesn't break out affiliates or subsidiaries.
So should we look at defining it? Okay, thank you.
It is defined elsewhere in statute.
Correct.
Can you simply reference that as defined in such and such and you're done?
Yes, that could be done.
Great, thank you.
Okay. Does anyone else have any questions right now? Not right now? Yeah, Senator Kramer?
Thank you. So if I understand correctly, basically what we've done is taken Virginia statute and just made that this bill. Am I, got that? Okay, thank you.
Well, there's a couple things going on, Senator. So we also, just as from a process standpoint, I think you were here, I'm not sure. We have a long list of folks who are going to also be participating, asking questions, and so it may be that they might have some of your questions as well. Is it okay? All right, very good. You good too? Okay. So, all right, so what I think that we can do now is, like I said, there's a significant list of folks who have signed up to come forward. I'm going to ask Comcast, which is Nancy and Tiffany. Nancy Libben, and is she here? Yes. And Tiffany Harvey, Chris DePietro, and Chris, there's a name here as well. It looks like, is that Pooja Talani? And Tyler Patton? Okay. So while you all two are there, I would just ask that, no problem. Okay. All right, well, we'll start with this then. But what I would ask is if you all, if perhaps one of the two of you all might be able to, since you guys are there, we would be grateful. There's a long, pretty significant list of people. I'd like to get everybody an opportunity to do that, and that was the reason why I was calling up. I really was calling you guys up as one, in essence, okay? All right, so we can start out with Comcast then?
Perfect. Just for the record, Tiffany Harvey, Vice President of Government Affairs for Comcast in Maryland and Delaware. And I'm going to cede my time to Nancy Lemon, who is
Yeah.
going to speak to our issues. Thank you.
Very good.
Great, thank you. Thanks for the chance to speak today, and first want to commend the committee addressing this issue. It's clear that you all have taken a very thoughtful approach to this, and we very much appreciate it. These are very complicated issues, and I think you can look to the way California has approached this, and you know, we can attest just having the experience of trying to operationalize a law like California's approach, how difficult it's been, and how many subsequent amendments and backtracking California has done to try to get it right. The Virginia approach, which you are taking, which, you know, is, I call it the Virginia approach, but I would actually say it's just a very sensible approach that gives Maryland consumers protections that they don't have today. Strong protections, the right to delete their data, the right to access their data, correct their data, to port their data in a format that is reusable for them on other platforms, are rights consumers don't have and that they want to have, but you're approaching it in a way that allows business to operationalize those requirements without doing harm to the services they provide to consumers, and in a way that allows us to continue to innovate and provide consumers the kinds of new services that they want and expect to see. One of the benefits of the approach that you are considering is that it is interoperable with other laws that are already on the books, not just in other states, but federal laws as well, and even the European General Data Protection Regulation, which many companies that do business in Virginia will also have to comply with. One of the things that some states have realized, I think, is that making small changes to laws that are on the books in other states to try to tailor them and make them unique to a particular state, in doing that, they create operational difficulties for companies that have to comply. This approach that you're considering does not do that. It allows us to continue to comply with these other laws, as well as a law that you would put on the books here, and therefore provide consumers strong protections across the board, and to continue to comply with other both national and international privacy obligations.
Thank you. I appreciate that. So, thank you. And also, folks, just so that we know, we can just like move directly into, what your thoughts are on this specific, what we have here is a work session. We understand what it is, so we can just get, like I said, so we're able to get through as many of the folks as possible. And we really appreciate that. Chris?
Yeah, Mr. Chair, members of the work group, my name is Chris DePietro. I'm here on behalf of several of my clients, but I do have one of my favorite clients with me today. That's Microsoft. Pooja Talani who was part of the team at Microsoft that worked on the Virginia legislation. So honestly, we have her here as a resource to this work group to answer questions. But I will cut to the chase for the issues that I had presented. I had emailed the staff in this committee about raising the issues that Senator Vidal just talked about the GLBA language. The language that I suggested be placed into the amended statute or the amended bill does not change the nature of what the intent is of that GLBA language. It just provides a little bit more clarity and certainty. So we offer that to the work group for their consideration on behalf of most of my financial services clients. And if you have any questions for Pooja, she, I think, would be repeating, and we don't want to do that. So we're here as a resource.
Thank you. I really do appreciate that. Before they leave, did the members of the committee have any questions for them? Yes, Senator Vidal.
Just a quick one. So what responsibilities do businesses really have under this bill? If I can ask the Microsoft
Yeah,
person.
thank you. So this bill lays out affirmative obligations that businesses would have to comply with, such as providing consumers the right to access their data, the right to port their data, as well as requires data protection assessments that would require compliance within businesses to show what they're doing, how they're processing the data.
All right, I appreciate you all. As I mentioned, so let's just have Tyler come on up, and
Thank you.
thank you.
Thank you.
And Kaylee. And this is an ongoing conversation, folks, so we're just trying to get as much input as we can right now. All right,
Mr. Chairman, members of the committee, Tyler Patton on behalf of Verizon Communications. In the interest of time, I'm going to say me too. You're going to hear from our subject matter expert from the State Privacy and Security Coalition, and I defer to him.
thank you, appreciate it.
For the
Kaylee.
record, Kaylee Locklear here on behalf of the Maryland Retailers Association. We just wanted to sincerely thank all of you for moving toward the Virginia approach. I shared with you in my previous testimony that we are supportive of this model. It addresses so many of the issues that I brought up to you all before. It keeps intact opt-in loyalty programs. There are broad obligations for all parts of industry across the board, and allows us to use data for security and fraud protections, which is really important to us. So thank you all for moving toward this model.
Any questions for either of those two?
Mr. Chairman, if I could I have Mr. Kingman go?
No, he's down on the list.
Is he on the
Okay,
list?
Yeah, I'm going to get to you, sir.
Perfect.
Okay?
Thank you, Mr. Chairman.
Yeah. So now, I'm going to get to you, all right? Yeah. So we're going to now move over to the folks who, just to kind of just keep a sort of a flow going here, of the folks who were generally favorable as introduced, okay? So can we bring forward Irene Lee, Hannah Abrams, and Michael Lohr, please?
Would it be possible there was one more advocate that came a little late and missed the sign up?
Who was that?
Maureen.
Maureen Audi from Consumer Reports.
Sure.
Is that okay? Thank you.
All right. Okay, let's start with Ms. Lee. Can you just put the mic, there you go.
All right, thank you, Senator, for having me here today. I'm Irene Lee. I'm here on behalf of Common Sense Media. Senator Lee's intention behind SB 11 was to protect Maryland residents, of course, their privacy, but specifically our most vulnerable population, which is our children under 16. And there is no bill without child protections in it. So the Children's Online Privacy Protection Act, for context, as it stands now, is not enough. It only protects children under 13 by requiring parental consent before businesses collect data from them. And as we have seen, it doesn't do too much to protect children, at least in today's technological age. So it uses an actual knowledge standard that allows businesses to escape complying with COPPA by basically saying they don't know that children are using their platform. And by now, we probably know that consent can sometimes be meaningless because privacy policies are so long, they're full of legalese, and we're probably not reading them, and even when we do, it's really hard to understand them. So we really advocate that the provision that prohibits collection of data from minors under 16 is restored in this bill. Children are particularly vulnerable because they don't understand the full complexity of how data is collected from them, how it's analyzed, how it's used for commercial purposes, and studies suggest that teens just have a more interpersonal, less technical conceptualization of privacy. And the privacy violations of particularly behavioral advertising are incredibly harmful. So we now know that 2 out of 3 products, because of common sense research, are used by youth, have privacy practices that track them on the app and across the internet for advertising purposes. And although the collection of data of children under 13 without parental consent is illegal under COPPA, companies can still collect and sell it because they are probably targeted towards a general audience, and so they can escape complying with COPPA. And also, children just use different technology these days. So they also use connected toys that can collect their images, their sounds, their location. So there's just so much more information that can be shared via the internet. And then there's also just problematic targeting and manipulation. I think we've seen that there's a Facebook memo that was leaked in 2017 that shows that Facebook can be identifying when teenagers and children are feeling incredibly insecure, worthless, stressed, defeated, amongst many other negative emotions. And behavioral advertising's efficiency is also just questionable. The benefits for publishers are quite minimal. Studies have shown that there's only a very small increase, if any, in using behavioral advertising, and that contextual advertising is arguably more effective. So in response to when GDPR was implemented, New York Times actually stopped utilizing behavioral advertising and focused only on contextual targeting, and their revenue actually increased. So behavioral advertising has so much harms that are imposed on kids and teens because they're so vulnerable, because there's so much data, because they're using technology so much, and they're sharing so much information out onto the internet. And so it really is necessary that COPPA, that we make changes to this bill that would actually protect them, as COPPA, as it stands now, isn't doing enough to be protecting them. So I, once again, just advocate that the child protection is
Thank you.
stored.
Thank you very much. Thank you very much. It looks like you got a question?
Yeah,
You're going to let
the
him
whole
wait?
panel go.
That's good. Thank you, sir. All right. Hannah?
Good morning. Thank you for letting me speak. Senator Lee has been introducing this SB 11. Can I turn this one on?
No, just pull it towards you. Just pull it towards you.
Okay, it's on?
It
How's
is-
that?
Yeah.
Excellent. Me and my tech. So Senator Lee has, been a strong advocate of privacy. And this kind of whole swath takes it and replaces it with the opposite of the spectrum. It's sort of the facade of privacy, but because of the definitions and the exemptions, it really doesn't achieve consumer privacy in the way that would be effective. And there are other laws that either have been passed or are pending that, use this framework, but incorporate some additional protections that would be important. So for example, and it's important for all of us to pass a privacy law. I think you heard industry saying it's important. Right now, what we have is consumers don't trust. And so, and there are costs to that. And we've heard that a lot of consumers have not signed up for COVID tracing, contact tracing, because they don't want their information collected. So it's not that there are costs to consumers and there are costs to businesses as well. So I think this is a very important issue. The definitions are critical. What we define as a sale, for example, what we define as consent, what we define as personal data. And I've submitted some written comments that I'm going to try to not go through entirely, to be brief. The other issue is the entity level exemptions. For example, we've discussed the GLBA exemption. So GLBA covers data that is coming from customers. You have to qualify as a customer for the to the financial institution to be protected by GLBA. That means that if you go to a bank's website and don't actually sign up, they can collect your data, and it's not covered by GLBA. So when you focus on the entity rather than the data, you are excluding protections for other people that might, and if you think about it, if you're not a customer, maybe you shouldn't be collecting their data. So the carve-outs are problematic. We've got nonprofits, we've got higher ed, and the definition of higher ed in Maryland law is extremely broad. So you're creating a situation where companies can qualify as higher ed and then not have to comply at all. The right to cure as drafted disincentivizes companies from complying. They have the opportunity and creates an excessive burden to the AG's office to have to notify companies, and basically, if there's no reason to comply, if you can just not comply until you're notified. And we just don't have the staff to keep notifying constantly, and it doesn't really create a system that is workable. The assessment section does not really take into account our current authority. For example, we don't issue CIDs, we issue administrative subpoenas, and it doesn't codify any additional authorities beyond what we currently have to the extent, so I'm not sure what that section adds. And then finally, the section that precludes actual damages from the Consumer Protection Act, this is separate and apart from the conversation about the private right of action. It's not clear why, if there's actual damages, if a consumer is harmed by a violation of this act, why they shouldn't be able to recover. That's a standard that exists in the Consumer Protection Act, and if you can prove that you were harmed, that you lost money because of something, it would behoove the company to have to restitute that.
Thank you so much, Hannah. All right. Next, we'll go to Michael Lohr from Senator Lee's office.
Thank you. I'll be very brief. Senator Lee would love to be here. Obviously, this is her top legislative priority, and she says that on a few bills, but this has been a bill she's prioritized for several sessions, and as soon as California's law was going forward, she requested this bill back in 2019, actually, I believe, or 2020. And this bill has been introduced several times in the form of California. So for years, we were told we needed to wait for California to enforce their law. California had some updates. And while all of that is true, this bill has kept pace with those changes in California. And Virginia's law is not in effect yet. So all of the talk about making this consistent actually is a little false, because the consistency would be to make this in line with California, which is already in effect, which, as the senator mentioned at the hearing, a lot of these companies, if not all, are already following. And over the course of several years, this has been a priority of the Cybersecurity Council, of which Senator Lee is the subcommittee chair for the Law and Policy Council. This has been brought up at several meetings, and we have explicitly asked anyone, any lobbyist, any individual company that's concerned about this legislation impacting them, to tell us if they are already not following the California law. And to this day, right now, no one has approached us. And I understand a lot of these groups are speaking on behalf of members because they don't want to tarnish their brand image, and I'm not going to start naming individual companies, but it's clear the Virginia law was written by more influence of companies than the consumer protection advocates. And it has been called different things, but it's derivative in some ways of what they were trying to do in Washington State and Virginia. You can make the connections if you want about why those states, but Colorado has subsequently passed a law that adds a provision that I think is really important. And if nothing else, I want to convey, if we're moving forward with this Virginia model, certainly we need to add certain provisions like the global opt-out provision. That's something California has in place and Colorado have. I just want to note there are a lot of other states moving forward with privacy laws. Oklahoma, they have a bipartisan effort where they're working to potentially even go further. Senator Lee's been working with the National Conference of State Legislators and was at their privacy conference this fall where we spoke, and she spoke to basically all the senators and delegates and representatives around the country that are working on privacy bills. And we were meeting in Virginia. We heard from the sponsors of the bill in Virginia, and they mentioned that they thought the consumer protection groups came in after the fact. Well, they passed their bill during a special session, and they passed their bill pretty quickly. So if the consumer groups didn't have enough to say, we hope they do here. So I'll leave it at that. Thank you.
Okay, thank you, Michael, I appreciate that. And you invited someone up, I don't have the name down here. Just, if you would, just tell us who you are, and then,
Chair, members of the work group, my name is Maureen Mahoney. I'm a senior policy analyst at Consumer Reports. I very much appreciate you letting me speak today. I've worked on state privacy legislation across the country, and I do have concerns about this draft. We would be opposed to the draft because while it seeks to provide important protections to consumers, which we value, it would actually do little to protect consumers' personal information and rein in major tech companies like Google and Facebook. So what's most important for us is to just make sure that the bill actually delivers on what it promises. A key protection would be for consumers to be able to opt out of the transfer of their information for targeted advertising and for sale, and it has to be really easy for consumers to opt out. But unfortunately, we've seen in California, it can be really difficult for consumers to opt out. First of all, a consumer would have to go to hundreds, if not thousands, of different companies individually in order to fully protect their information, which just isn't workable. And it can be also difficult for consumers to opt out individually at one company. We did a test and found out that 14% of the time, the opt-outs in California just didn't work. So there needs to be some sort of global opt-out, a way for consumers to signify in a single step that they want companies to stop selling their personal information. There is a tool called the Global Privacy Control, which has been developed by researchers and academics. It's required in California. It would be required in Colorado in the coming years, and we think that would be really important to making it workable for consumers. As some of the other panelists have mentioned, the definitions need to actually make sure that any information made available or transferred for a commercial purpose is covered by the opt-out. And enforcement is important to ensure that companies can comply. We would recommend either removing or sunsetting the right to cure. Enforcement is really important to incentivize compliance, and if the only thing that could happen is a confidential letter for a non-compliance, that's not going to incentivize compliance. So thank you very much for the opportunity to speak today.
thank you so much. Senator Kramer.
Thank you, Mr. Chair. And as I look around the room and seeing that we've got an entirely different bill before us, but I think looking out across the room with the new bill, we need a new title that this would be the Lobbyist Full Employment Act of 2022. And Michael, I agree with you that my concern with all of the industry support for what's before us at the moment is that it's probably because the bill doesn't do anything anymore. So I'm also reading the tea leaves, and that would lead me to believe that we're going to try to find some compromise here between where the industry is and where those who are concerned about consumer protection are. Do you think it is possible to work off what we've got before us right now, and I'll ask that of all of you, just to take this and focus on where you see the weakest links? And I agree that the notion that I have to start contacting entities that I probably don't even know exist and opt out of their collecting my data, that's just ludicrous and clearly impossible to accomplish. So, the notion of a global opt-out, the ability to enforce what we have here without having to somehow assert certain actions that are, required existing, in here, also doesn't work. But do you all think that you might be able to target, working off Virginia, things that maybe could make it palatable in the name of compromise, and work off this? Or do you think this is just not even a starting point? Can you share with me real fast your
Yeah,
thoughts on that?
I'll tell you my personal opinion as a non-expert staffer who just I've seen the legislative process for almost a decade now around here, and I think we can do this. I think if we prioritize this issue and child safety, that would be worthwhile, and I think we can do it. I think there's some provisions that need to come back in, but I think as a model, this is something we can build off of. Again, Colorado has something similar. Washington was discussing this. We don't necessarily like this as a model, but there are provisions that are consistent with the GDPR, which is great. And we think if companies are already following the GDPR and the CCPA, Marylanders should have similar, if not, the same protections as they do, because they're basically hitting a switch and turning off our protections where they have those on in other states. So I would like, meaningful language, but I would just, the premise that this is not going to evolve over time is a little misleading, because Virginia is already potentially changing their language, and again, it's not in effect yet. So, there's going to be a privacy bill before the General Assembly probably every year for the next 2 decades, I imagine. So I would hope that if we're going to spend all the time, spinning our wheels, that we push a policy that we can have in place for at least a term.
But do you think you can work off
I think we can.
this
I think so.
in a timely fashion, because TikTok, we're getting to that point where
Yeah.
things are going to have to be finalized,
We'll
in our truncated legislative session, so.
I can only speak on behalf of Senator Lee. I know her prime priority is the protections for children. So speaking of TikTok, the COPPA was created, in the Windows 95 era. It wasn't created in the TikTok era. So I would agree that the TikTok, we need to move. And I have a
Okay.
1-year-old at home, and I'd like his protections to begin before he starts using the internet.
All right, so you all are going to take that as a goal and maybe get to work quickly on it, and then maybe we can find, I don't know whether the industry is capable of putting forth a couple or 3 representatives, Mr. Chair, to maybe even meet with you all to try to hammer out certain things, but I think this is a good place then if we can build off of this. So,
All right.
thank you.
Thank you. Anybody else have questions?
Questions, but I think that's an excellent idea, because this is such a big issue, and it looked just to me that we're on 2 sides of the page, and as the TikTok goes, we're running out of time. So if you guys could get together without us asking lots of questions and everything, and come up with some kind of compromise, I think it would really be good.
Well, Senators, just so that you know, that's part of what this process here today is.
And I know, I
Yeah.
get that, but.
And they are
But we
sharing
have
info.
But we have 1 hour here.
Yes, ma'am.
We have 1 hour, and the time is ticking away, and you all need to do that, because, again, all the lobbyists are in here. We need the consumer rights and looking out for the children, and I just think that's a good idea. So.
Okay, wonderful. Thank you, Senator. Thanks, everyone, for your input here. We do have this one person signed up, Phil Kandrazaski. Come on up. Sorry about my pronunciation, sir. Sorry about that.
It's all good. I understand. And just to clarify our position, Phil Konjerski here on behalf of the League of Life and Health Insurers and the American Council of Life Insurers. We are generally supportive of the Virginia model. However, we think that the insurers have a unique position here, as we are very close to a deal on Senate Bill 207 with the MIA Insurance Commissioner, which would create additional levels of oversight when it comes to cybersecurity. And I think at this time, we aren't sure how these additional oversight will meld with the Virginia model. And we'd like a little bit of time to figure that out. And so I would say that generally our position is in lockstep with the industry. However, we do have that one slight difference.
Okay, thank you. Thank you very much. Anybody have any questions? No? All right, I appreciate that. So
Thank
we're
you.
going to now go to the next set of folks who signed up favorable. So we have Caitlin McDonough. Caitlin, are you representing multiple clients, or are you just, all right. And then we have Bryson Popham here on behalf of T. Rowe Price. Steve Sakamoto Wingo, I see you on here, but Hannah obviously is, were you going?
I'm deferring to Hannah.
Yeah, that's, okay, thank you, I really appreciate that. And then Lisa McCabe would be the fourth.
Yes. Mr. Chairman, do I have your permission to bring Mr. Enton up here? He was late to the work group.
Absolutely not. No, I'm just kidding, just kidding. All
It's
right,
underneath my turtleneck. I can assure you his presence is essential,
yes,
Mr. Chairman.
I'm sure of that. Okay, Caitlin.
Good morning, Mr. Chair, thanks. And just, I won't go into a lot of details, but just kind of listing clients. We work with Verizon, we're working with LexisNexis, we're working with several large retailers and pharmaceutical manufacturers, and I just only mentioned that just to kind of, restate the widespread implication of the legislation. I think we join with the rest of industry in supporting the move toward the Virginia model. And the only thing I would note is Virginia did just pass last year, so in their session, which I think just ended or is about to end, there were some kind of, I think, somewhat substantive, but mostly corrective tweaks to that legislation. So we're kind of looking through that to see if there just need to be some updates to reflect current Virginia, or what will be current Virginia in the next couple weeks. And again, very minor corrective things that I'll get to Patrick, and it shouldn't have overall substantive impact. But thank you.
Thank you, Caitlin. And then Bryson and Bob.
If I could, Mr. Chairman, first of all, thank you for letting me come to the table. There was a bad accident on 97 today, and I was late getting down here. On behalf of the Maryland Bankers Association, on behalf of the American Property Casualty Insurance Association, and I think also, having talked with the securities industry, these are the types of businesses that are subject to Gramm-Leach-Bliley. And, Gramm-Leach, we've heard discussion about, California versus Colorado versus Virginia. And the one thing that applies across the board to our clients, and Mr. Popham's as well, and some of the other people in the room, is federal Gramm-Leach-Bliley. It applies every place. We must comply with it. We have consistent policies amongst our businesses. And while you have, I think the exemption language in Virginia is great, what I'm not clear about is, kind of stylistically, when you say, and I've had this conversation with Mr. Carlson and some others, when you say a financial institution, blah, 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 there's no definition in the bill of financial institution. And when you look at the other bills we have on laws we have on the books today, like the PIPA, the Personal Injury Protection Act, it says an entity subject to. So I think you have two choices. You can either define financial institution to say an entity, blah, 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 or you can just, I think the easiest thing to do would just be say an entity subject to, and then you'll pick up the types of businesses that are already heavily regulated in this arena. That's, I think, the primary concern. The other concern is when you look at the PIPA statute, and I know you've got the biometric bill in front of you right now, and that's also pending in the House, a bill that deals just with biometrics. That picks up kind of the PIPA language, which says it applies to an entity subject to Gramm-Leach-Bliley or an affiliate or subsidiary of that entity. Because whether you're a securities company and you kind of divide your book of business into 2 or 3 different entities, you're all going to follow Gramm-Leach-Bliley. And it's interesting that since the PIPA statute was enacted, I'm not aware of any cases that are out there against the securities industry, the insurance industry, or the banking industry. And that's because we do follow Gramm-Leach-Bliley. So that's our primary concern, Mr. Chairman.
Thank you. Appreciate that very much.
Thank you, Mr. Chairman, members of the work group. Bryson Popham on behalf of T. Rowe Price this morning. I have 3 very brief comments. First of all, I support Senator Beidel's early suggestion about definition of financial institution. I think that has been certainly discussed, and perhaps there's agreement on that. Not discussed, however, was the term affiliate, or at least not
clearly and completely. I believe Mr. DePietro has sent comments to Mr. Carlson on that, suggesting the inclusion of affiliates as well. That's important. Those are my two GLBA comments. With respect to biometrics, I have no language to offer. However, I do want to offer the work group an example of the challenge that we face. As you know, T. Rowe Price is a very large global financial services firm. They service, among other things, the state's 529 college savings plan. It is in there, and we are dealing with this on cybersecurity in other legislation. They have a very robust, multi-level cybersecurity plan, which includes biometrics. And that is an important layer of protection that applies to all of their customers, many of whom are Maryland citizens, and those who participate, for example, in the 529 plan. I have just seen this reprint this morning, Mr. Chairman. I'm going to send it to my client immediately after this meeting. If we have some comments or suggested language, we will get them to you immediately.
Thank you, very much appreciated. Anyone have any questions for this group? Oh, I apologize. You're right. Ms. McCabe, Lisa McCabe.
Hi,
Sorry.
Lisa McCabe, on behalf of CTIA, the Trade Association for the Wireless Industry. And we too are supportive of the amended language and taking the route toward the Virginia statute, and appreciate that. Thank you.
All right, I apologize, sorry about that. Yes, sir.
Thank you, Mr. Chair. So, in that regard, are you willing to spend some time working with the folks who were in the panel before? If I were to look at you right now and say, look, for me, this doesn't come out of the starting gate. Whether that ends up making a difference in the outcome of what happens in this committee, no clue. But I appreciate your coming up and saying, we support what's before you right now, because it pretty much doesn't do a thing, and we're all behind that. Are you willing to sit down with the folks who are just here and give some serious contemplation and thought as to how we can work off the document, the Virginia law, and actually make it viable? Are you willing to do that?
Yes, and I can bring that
Thank
back
you.
to my members as well. Thank you.
Thank you. I appreciate that. Thank you, Mr. Chair.
Thank you, everyone. We do have the next set of folks. Mr. Kingman, Chris Gellerin from TechNet, Tara Ryan from ESA, and Ms. Ryan, it's you and Maya McKenzie, is that right? Okay. All right. Very good. Thank you. All right, Mr. Kingman.
Yeah, sure. Yeah, good morning. Can folks hear me okay? Thank you. My name is Andy Kingman. I'm General Counsel to the State Privacy and Security Coalition. Our coalition spans a number of sectors, from telecom to technology to payment card to retail to automotive. And so, we also appreciate the committee's attention to this matter and are supportive of the model being discussed here as the amendment to SB 11. I think there are any number of attributes, but I think the biggest one is that it strikes that balance between what we know is a complicated subject and what we know is difficult to speak to consumers about and have them have the appropriate set of rights and controls over their data, but also make sure that it avoids the negative impact to small businesses, as well as the operational difficulties of larger businesses. And so, we believe that it does strike the right balance. I think, a couple of things that I wanted to address here that some other folks have brought up. We view the right to cure as a very, very important part of this. I represent the coalition. I also counsel clients through compliance programs and working through operationalizing, whether it's different privacy laws across the country here. And so, we know what some of the operational difficulties are that this bill eliminates. Having said that, we've also seen in California, the Attorney General's office expressed that about 70% of the businesses that they have that have come into compliance excuse me, let me rephrase that the Right to Cure has been a very valuable tool in helping companies come into compliance, and about 70% of the compliance actions that the OAG has taken out there have been through the Right to Cure. And that's because it's a very low resource way to simply send a letter if you get a complaint from a consumer, hey, this business isn't offering me the right to opt out, et cetera. It doesn't require starting an official investigation. It allows the business to reevaluate whether it needs to come into compliance or whether they're missing something. And then it requires the business to expressly promise that there will be no such further violations in that of that requirement here. And so we view that as a very important way. If the goal here is to make sure that businesses comply with the law, we view that as an important way. I think some people view it as a loophole, that a business can just ignore complying with the law and just wait for a letter. And I can say that whether it's a large or small business, there's no way to operationalize the entire law and create the back-end architecture and retain vendors within 30 days. It's just simply not a possible thing. So the idea that businesses wouldn't comply until they received a Right to Cure notice, I think, just isn't necessarily borne out by practical experience. So just wanted to bring up a couple of those issues.
I appreciate that. Thank you very much. Mr. Gillerin?
Thank you very much for the opportunity. Chris Gilrain with TechNet. We are an industry association representing about 95 companies in all facets of the innovation economy, from the companies that you'd expect, like search and marketplaces, through advanced energy companies, autonomous vehicles, a whole gamut of innovative companies. Just to illustrate the range that we have a lot of niche issues, but the thing that unites everyone is an interest in consumer data privacy. I'm not going to try and be repetitive. We do support the amendment that's before you, moving toward this model. As Andy mentioned, if the end goal is protecting consumer privacy and getting companies to comply, I think this is the way to do it. The roles and responsibilities for companies and the rights for consumers are explicitly laid out in statute. It's not subject to concurrent rulemakings like we've seen in California, which have changed and often overlapped with one another. One piece that I just want to highlight that is preferable in the amended version is TechNet has a series of policy principles. It's kind of like our Constitution that everybody agrees to at the beginning of the year. One of those principles is that privacy statutes should have specific remedies tied to specific potential risks. This bill does that. It treats different classes of data and different processes in different ways and has a higher level of care for more sensitive data. So we do appreciate that about this, the amended version. But we stand by and want to be a resource to the committee as you move forward.
Thank you very much. And next, we're going to hear from Maya McKenzie. While Maya McKenzie, you're speaking, could Jake Parker come on up? You're the last person who signed up as well. Please.
Thank you. Good morning. My name is Maya McKenzie, and I'm representing the Entertainment Software Association, which is the trade association for video game publishers and console makers. Our industry takes the matter of children's privacy specifically very importantly, and for that reason, we are generally supportive of the amendment, which mirrors the Virginia model, in large part because it aligns with COPPA, which is the federal children's privacy law. There was some illusion that this was an old law created when, in the days of Windows 95, but the FTC, which enforces COPPA, has implemented additional rules and informal guidance over the last 20 years. In fact, the FTC has expressed its desire to revisit those rules to be sure that they are in touch with the times. And this bill, as drafted, appropriately takes into consideration the vast guidance and rules that address children's privacy in today's age. And so for this reason, we are supportive and look forward to thoughtful collaboration on children's privacy.
Okay, thank you very much. And next, we'll hear from Mr. Parker.
Hi, Jake Parker here with the Security Industry Association up in Silver Spring, Maryland. We represent companies that provide security and safety technologies. So protecting data is definitely a key part of what the mission of our industry and our members. And we're here to support, like many of the others, the amendment here today, not because it doesn't do anything, but because it affects everyone, in the business community and all the consumers. So, we think one reason to support this is that it reflects the current state of technology in many ways. So it's an updated way of addressing this versus what was considered many years ago in other places. Key provision that's important is the security provisions in the alarm sector, those providing those systems for consumers. Need to be able to share alarm information with first responders without first having to establish data management contracts. Those agencies require deletion and all these other aspects. So we definitely support that. Also, an appropriate enforcement mechanism that doesn't create a bonanza for class actions, as we've seen in some other legislation, is important. And then lastly, biometric data is becoming increasingly important, something that a number of folks here in the legislature want to address. This would address biometric data in a stronger way. It has actually a broader reach of what is covered as far as biometric data versus other data privacy models. And it's more accurate as far as what the definition is. And it's even more broad than what's in the Illinois Biometric Information Protection Act. So for those reasons, we support the amendment.
Okay, thank you so much. Any questions from members of the committee? No? All right, so I want to say thank you to everyone for this. You've given us a lot to digest and to work through, and we will do that. We'll confer, obviously, with the folks who agreed to work on this, and we will circle back to everyone. So thank you, everybody, for your time today. We really appreciate the input.